I think we're set. On the record, please. Court calls case 2021 CF 110, State of Wisconsin versus Rashawn Brett Hansen. Appearances, please.
State appears by Assistant District Attorney Rebecca Meyer.
We just lost Cortez. Mr. Hansen, is that you?
Yeah, that's me.
Okay. Cortez was just here and she just dropped off. Go off the record, please, till we get our defense attorney back. I'll be right back.
Attorney Cortez. Hi. We just slightly paused so that I think you had dropped off Zoom for a little bit, so that it was just allowing you to relog back in.
Okay, thanks.
No problem. He should be back soon.
Okay, thanks.
Is back. All right. Go on the record again, please. Court calls case 2021 CF-110, State of Wisconsin versus Brett Rashawn Hansen. Appearances.
State appears by Assistant District Attorney Rebecca Meyer.
Good afternoon, Your Honor. Attorney Nalita Cortez appears on behalf of Mr. Hansen, and I do see Mr. Hansen appearing via Zoom as well.
All right, so this matter is set for a final pretrial. I received a motion to adjourn. You're supposed to have oral rulings too. I have to tell you, I'm somewhat at a loss. Exactly, other than the state's motions in limine, I don't believe there were any other outstanding motions I was to decide today. Specifically, there was a reference to 90808. I do believe there was, well, here it is. There was a motion to admit audio visual testimony, so that still remains outstanding. But I thought the defense was not objecting to that, and I just needed to make findings, was my recollection. But I now understand Mr. Hansen may have an expert. So Attorney Cortez, maybe you can take it from here.
Thank you, Judge. There was that motion that the court just touched on. There was also a motion filed by the state on November 18th regarding their intent to ask that the Children's Hospital doctor, Dr. Judith Guinn, Guinn, that she be found as an expert. So there's that motion as well. At this point, Mr. Hansen has been able to save enough money to hire an expert. So I do have communications out to someone. Actually, this is the third person that I'm reaching out to see whether or not they would be able to assist on this case. I did have a conversation with ADA Meyer earlier today. She was kind enough to give me a call. And I let her know that as well, that I'm pursuing that. So I have not been able to respond to the state's motions. I do want to respond to the state's motions. So that is why I'm asking the court to adjourn its decision. Also give me time to see if I can get this expert on board now that Mr. Hansen does have money to pay for an expert. And that's where I'm at, Judge, with those issues.
Are we in compliance with victim rights legislation?
Yes, Judge, we are.
And has the victim been made aware in the jury trial?
Judge, I am not aware if the victim has been made aware. Adjourn. I can tell you there is no objection to adjournments on file as part of victim rights, but I do not believe the victim was called regarding the motion to adjourn a jury trial.
What's the state's position?
Judge, this case is a relatively old one. It's back from the YouTube era. However, in the interest of justice, I think it's only fair to allow the defense an opportunity to find an expert as to responding to the motions. These motions have been outstanding for over 6 months. I think I would object to allowing a response. She wanted to respond, she could have responded in the last 6 months. However, I think I'm going to take no position on it. It's up to the court.
Say it again.
I take no position on whether or not the court allows Attorney Cortez to respond to the 2 motions that have been outstanding for over 6 months. As for adjourning the trial, I also take no position on that as well.
So Attorney Cortez, do you anticipate, and I know we had multiple defense adjournments, I've not been able to track through the history of the case. In fact, I didn't even see the audiovisual motion. I knew when it was filed, but I couldn't even find it in the file because of how long this is, going on. Victim's still likely gonna be under 12 no matter what, relative to the 90808. Just so I understand, you're gonna respond to Dr. Gwynn, which happened November 18th. I don't believe there's been a Daubert challenge. Are you reserving rights to do all those things?
Yes, sir.
Oh, I didn't hear you.
Yes, sir.
Your audio's not working.
Yes.
Okay. Rashawn, can you hear me?
Yes, I can hear you.
All right, so Attorney Cortez, I think your microphone's not working.
Can you hear me now?
Yes, I can. So is the answer yes?
Yes, sir.
If the state's taking no position, we don't have any, we don't have any victim rights, Marcy's Law concerns on adjournments, Class H felony, 2 counts. Sir Hanson's facing a lot of time here. The cases go to trial, but I also am concerned, in light of the record made by Attorney Cortez, that she's also, in addition to all these things, suggested she's not prepared to go to trial, which would raise effectiveness issues if I don't grant this adjournment. And I'm looking at her motion filed today. She indicates she needs additional time to prepare. I mean, I think that alone, in the absence of any objection from the state, gets you there. And no questions that Attorney Cortez can defend this matter prepared, but there's been issues relative to health. Is what it is. And so on that basis, I'll grant the request to adjourn the trial date. Otherwise, we're trying this case multiple times, and I'm concerned that then the victim would have to testify potentially multiple times, because defense counsel has indicated she's not ready. Now, whether she could have been ready, should have been ready, the state's not challenging that. So that's the current circumstance. So we'll take the trial date off the calendar. I guess, Attorney Cortez, for clarity purposes, I know I just asked this, but there's a 90808 motion pending. I have to find the disc. I don't even know if I've been provided with that. I was pending to review and get ready for today, but I'm able to even track down the motion when I was looking through the file. currently do have motions in limine filed, the state has motions in limine filed. Is there any reason to file any more motions in limine? Aside from perhaps what you're doing with Dr. Gwynn?
No, not aside from that.
So freeze that. On the 90808, I believe victim one's going to be under 12, which really limits the court's inquiry under, as to admission, because the interest of justice standard doesn't apply. And I don't believe the state is offering an expert beyond Gwynn. Am I correct?
That is correct.
They are going to have forensic interviewer Samantha Nauman. Is she going to offer opinions on anything relative to the forensic interview?
Not to my knowledge, no. She would just be there to explain the process, how they tell how a child is interviewed, and truth and versus a lie. That kind
And
of
what?
truth versus a lie, how they go through that with the child.
Right, but the video's going to say that.
The video is going to speak for itself, I believe.
So Attorney Cortez, you anticipate a challenge to the 90808 video?
That is possible depending on what my expert says after reviewing the video, and that's the expert that I'm in the process of trying to retain.
And are you also getting an expert to respond to Gwynn?
To be honest, no. If Your Honor allows Gwen to be classified as an expert, I have questions I'll be asking of Dr. Gwynn as well.
Well, the at least in terms of, and I'd have to look back at the file, but my preference is to have the state declare expert rather than not, and then run into a situation where you say she's testifying as an expert. Dr. Gwynn, I believe was I don't know, was a contemporaneously treating physician here. I don't recall.
I would classify it as delayed treatment because the few weeks did pass.
Correct. And so whether, I think the state is offering her testimony as an expert. If you're going to say it's not expert testimony, then I don't think we have Daubert concerns. But and I have to move on to child support. What I think we should do, because I have my other hearings are backed up a little bit here today, is to set a scheduling conference in about 15 days. I'll have my judicial assistant get a hold of you, Attorney Cortez. The reason I'm doing that is I think we need to identify the exact issues that remain and then establish deadlines for the defense. And that'll give you time to figure out perhaps better who your expert's going to be and what time you're talking about. Otherwise, we're going to be right back here with the same problem.
Okay, thank you.
Do you have any objections to that?
It has no objection to that.
Okay. I don't know there's more we need to do then. I'm adjourning the trial, take the trial off the calendar, and then we'll deal with the defense side of this. And I think the defense is going to have to be prepared. I think the testimony offered by the state is clearly expert testimony. I don't know how it isn't. Dr. Quinn. But maybe I'm wrong on our 90702, 90701. I don't recall Dr. Gwynn being a contemporaneous treating physician. She may have been brought in as oftentimes experts of children's are to specifically try to identify if there's indicia of abuse. And I think it's always safer to do a disclosure and have it rendered unnecessary because the parties agree that the person can testify as qualified to do so, than have it the other way and run into a problem at trial where you're, asserting a Daubert challenge at trial. Now you're on notice. Makes sense, Attorney Cortez?
Yes, sir.
So I'll get my judicial assistant to get a hold of you, and we'll set this out for scheduling conference about 15 to 20 days. Hopefully, Attorney Cortez, you'll have made progress, all right?
Thank you, Judge.
Mr. Hanson, you're fine with all this?
Yes, Your Honor.
Okay, so we'll go off the record. Thank you.
Thank you.